Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. For more information on any of these stories, download our news in document using the link in the top right of the screen. On the 26th of June, changes to the People with Significant Control, the PSC regime, were implemented. The changes include reducing the categories of companies that had previously been exempted and requiring changes to PSC details to be updated in the PSC registers within 14 days of the information being received and notifying Companies House within a further 14 days. Updates need to be sent using new Company House forms rather than the confirmation statement. Useful guidance is available on the government website. Contracts often refer to a party's obligation to use reasonable endeavours, but what does that term mean? A recent High Court decision said that the test is what a reasonable and prudent person acting properly in their own commercial interest and applying their mind to the contractual obligation would have done. The court noted that it's not unreasonable for a party to refuse to take an action that would have been useless. In a recent case, a ship on hire was returned 2 years early in breach of contract. The ship owner could not hire the ship to another party and instead sold the ship and made a claim for the lost hire charges. It was acknowledged that the ship owner achieved a sale price that was over $16 million more than could have been achieved at the end of the agreed hire period. The court had to decide whether the ship owner's claim should be reduced by that $16 million. The Supreme Court has ruled that the ship owner was not required to pass the benefit of the higher sale price. Whether a party is required to pass on the benefit will depend on whether the benefit was caused by the other party's breach of contract. It's common in contracts for parties to define terms to have a particular meaning and state that the particular meaning will apply when the term is capitalised. In a recent case, practical completion had been defined but used inconsistently, sometimes capitalised and sometimes not. The court determined that where the term was not capitalised, it did not have the defined meaning. This small drafting error was ultimately critical to the defendant, leaving it with the liability for flood damage. We have previously reported on cases concerning subject access requests. As a result of these cases, the Information Commissioner's Office has updated its Subject Access Code of Practice. The guidance states that data controllers should try to engage constructively with the individual making the request. The ICO will not allow a data controller to invoke the disproportionate effort exception to refuse to supply data without engaging with the individual to determine what information is actually required. In the tribunal case of Ali v Capital Customer Management, the tribunal determined that an employer's refusal to only offer enhanced contractual maternity pay to mothers was direct discrimination against male employees. It's understood this case is being appealed. The controversy of the gig economy continues to spark debates. In addition to the multiple cases of employment status definitions that are working their way through the courts, here are the other issues that are being raised. The Advocate General has given an opinion in the case of King v the Sash Window Workshop and Dollar, stating that employers that wrongly classify workers as independent contractors and therefore do not pay holiday pay will be liable for full backdated holiday pay claims. A case is being brought by Andrew Boxer and a trade union to challenge whether TUPE rights apply to workers, and the Taylor Report has made some significant change proposals for the gig economy, including changing the name and definition of a worker, creating a new national minimum wage calculation and setting higher minimum wage for zero-hour workers. Whether the report makes its way to legislation remains to be seen. In the case of Jade Bay Limited v Clark Coles Limited, the defendant has used the Amazon function to sell an item using another seller's listing of the same product rather than creating its own. The seller that sells the product at the lowest price usually becomes the default seller which Amazon promotes, enabling it to achieve the most sales. The listing in this case for flagpoles used Jade Bay's trademark, but the defendant's product was its own brand of flagpoles. The Intellectual Property Enterprise Court, IPEC, has ruled that the use in this case of another party's listing was trademark infringement and passing off. The Court of Appeal, overturning an earlier IPEC decision, has ruled that an independent car repairer's use of a BMW wordmark on its shirts, Twitter account and van was trademark infringement. In order to prove trademark infringement, BMW was only required to show that the use was misleading and not, as IPEC had ruled, that whenever a consumer sees the use of the brand in this way, will assume that there is an official connection. The Competition and Markets Authority, the CMA, has developed a screening for cartels tool to help companies screen their tender data for signs of cartel behaviour. The tool is free to use and is available via the CMA's website. Thank you for tuning in for this month's commercial bulletin. For more information on any of these stories, please contact Radius Law or my colleagues at LexisNexis. We'll be back in September with more of the month's key legal updates.